Walking into court for the first time can be really nerve-wracking. You don't know what to expect, you're worried about what might happen, and the whole process feels really intimidating. But here's the thing. Your first court appearance, it is important, and knowing what to expect can help you feel more prepared and in control. But the reality is that very little happens in the first court appearance outside of your conditions of release. I'm Joel Chorney, and I'm a criminal defense attorney in Tucson, Arizona. And in this video, I'm going to walk you through what exactly happens at your first court appearance, what you need to do, and what mistakes to avoid. Before we get started, let me read you my disclaimer. I want to be clear. I'm only licensed to practice law in Arizona, and this video is meant to be informational and educational. Nothing in this video should be taken as legal advice, and watching this video does not create an attorney-client relationship with me. Every case is different, and if you need legal advice specific to your situation, you should consult with an attorney. If you'd like to speak with me about your case, you certainly can contact my office. Now, what should you expect at your first court appearance? Step 1, understanding the purpose of the first court appearance. See, your first court appearance is often called either an arraignment or an initial appearance, depending on your charges. This hearing sets the stage for your case, but it is not the trial itself. What happens at that first court appearance? There's several things. First, the judge is going to inform you of your charges. Now, this can be done in a way that you only see it in writing, when what is done is called waiving the reading of the charges. And that's something that is often done to avoid having the charges read out loud so that other people can hear what you're accused of. And that's particularly important in sensitive types of cases. Generally, the judge will announce to you what it is you're being charged with. You're also going to be asked to enter a plea, and this is generally either going to be guilty, not guilty, or no contest. Now, pleading guilty means you're conceding that you're guilty. You're conceding your guilt. You're conceding the fact that you are guilty. Basically saying, I'm not going to make the state prove my guilt. I'm just going to admit it. This is very rare for someone to do at this stage of their case. The reality is that it is understood by everyone in the know that the first court appearance is where you're going to enter a plea of not guilty, whether you absolutely did what they are accusing you of or not. It's just a way of making the process carry forward. Everyone in this country is presumed innocent until proven guilty. So it is not a lie to plead not guilty at the beginning of your case because you have not yet been proven guilty. You are presumed not guilty. And it would never be held against you the fact that you did plead not guilty early on in the case, even if you got convicted later on in the case. So that's the plea of guilty, which is very rare at the initial appearance phase. Similarly, a plea of no contest. A plea of no contest is similar to a plea of guilty in that it basically is saying, I'm conceding that the state's going to be able to prove my guilt, and therefore you're sparing them the trouble of doing so. The difference is that you're not admitting guilt. You're saying, I'm still saying that I'm not guilty, but I'm not going to make the state prove that I am guilty. I'm just going to not contest it. And that is something that, depending on the jurisdiction, is more available or not. In my jurisdiction, it is rare for the prosecution to allow a defendant to plead no contest. Usually, that needs to be an agreement between the parties that one party be allowed to do that, to plead no contest. But I've been in other jurisdictions where it is actually quite common. It's almost the norm, particularly in cases where the person's mental state at the time of the alleged offense has been impaired. Think DUIs and things like that, where a person genuinely doesn't remember what happened, but they look at the evidence and they recognize that the state's going to be able to prove that they committed the crime that they're charged with. So it really depends on your jurisdiction if you're even allowed to plead no contest. But regardless of whether you're allowed to or not, it's unlikely that you would plead no contest at your initial appearance or arraignment. So that leaves us with the not guilty plea. And as I mentioned previously, that's just saying, I am going to not admit guilt at this point. I'm going to force this case to move forward. I'm going to force the state to prove the case beyond a reasonable doubt. And that's just standard. The news media loves to make a big deal out of the fact that a high-profile defendant has entered their plea of not guilty. Think of cases like the shooting of Gabby Giffords, where Jared Loughner had his initial appearance and he pled not guilty, and everyone up in arms. How could a guy who was viewed by dozens of people committing the crime go and plead not guilty? But that's how that process began. Pretty much every high-profile case that you've heard of has begun with a not guilty plea. because that's how pretty much every case begins. The last thing, and potentially the most important thing for you that happens at an initial appearance, is the judge's determination of your conditions of release. The judge will decide whether to release you on your own recognizance or to set a bail that you have to post in order to be released from custody, or in some instances, the judge can determine that you're not going to get out, that you're not entitled to get out while the case is pending. This is reserved for very serious situations where either the crime itself warrants it, or a person has already demonstrated that they're not going to comply with the court's orders. Here in my jurisdiction, here in Arizona, this is common when a person picks up a new felony offense while they were already on release for another felony offense. The law allows the judge to say, you know what, we let you out and you went and you picked up new felony charges, so we're just going to hold you now during the pendency of this new case. That is the most common way that happens, but that's a possibility as well. It's important to recognize that the first hearing is not about arguing the case. It's not about presenting evidence. That comes later. In fact, if you ever have the opportunity to watch initial appearances or arraignments, anytime a defendant starts trying to argue about the case or trying to persuade the judge of their innocence, the judges are pretty quick to put an end to that, because that's really not the place for it, and it's a waste of time. Even if the judge were persuaded, the judge at that moment is not supposed to be determining guilt or innocence. So it's just not the right time for it. So don't be thrown off by the fact that at that phase of the case, no one's really worried about whether you did it or not, which sounds strange, but that's the way it is. Step 2, how to plead at your first appearance. Well, when the judge asks you how do you plead, your best option in most cases is to say not guilty. I've been doing this for a long time, and I've never encountered a situation where it makes sense to plead something other than not guilty at the initial appearance. But actually, as I just said that, it occurred to me that there is a rare possibility that the state has charged something in such a way that it's less than what they could have charged with, but if you got convicted of it, double jeopardy would attach. They would not be allowed to change those charges down the road if you've already been convicted. And so in that situation, it might be worthwhile to lock in that conviction for that lesser charge so that they can bring more serious charges. But that's not likely to come up at the initial appearance. That is something that a skilled defense attorney can be on the lookout for. And I certainly have counseled clients to plead guilty to something because I recognize that the state has made a mistake in how they've charged the case. And if they realize the mistake, they will fix it. But once the case ends with a conviction, they can't fix anymore. So that's a situation where that could happen. But that's not so much at the initial appearance stage, although it's something for a defense attorney to be thinking about. So you might be asking yourself, why is the not guilty plea, I should say, the plea that you should enter at your initial appearance? And as I mentioned previously, the not guilty plea doesn't mean you're denying everything. It just means you're going to give yourself and your attorney time to review the case and look at the evidence and explore possible defenses. The truth is that a defendant, even when they did the thing they're accused of, they're not in the best position to know what the evidence against them is. The state has presumably conducted some kind of investigation. They have had discussions. They have gathered evidence that the defense has not received at that point yet. And so it is reasonable that the defendant is going to want to review that evidence and see what does the state have against them before they determine whether or not the state can actually meet its burden of proof beyond a reasonable doubt. Fortunately, in our system, even if a person did the thing that they're guilty of, if the state can't prove it, that person is entitled to the presumption of innocence and they're entitled to be found not guilty, because we live in a country that has a system of laws and processes that requires proof. There's an old adage. It's been attributed to Ben Franklin. It's been attributed to Thomas Jefferson. I'm not quite clear who said it, but it's pretty well known in my circles, which says that it's better to let 100 guilty men go free than to convict one innocent man. And so the idea is that we would rather err on the side of letting bad actors go than putting people who are innocent behind bars. And so our system is designed with that philosophy in mind. And so there's nothing wrong with a person who knows that they did what they're accused of to plead not guilty. Nothing illegal about it. In fact, that's the way the system is meant to work. A few common mistakes that you want to avoid. Pleading guilty just to get it over with can have huge consequences. You don't want to just plead guilty. You need to trust that the process is there to protect you. The longer it takes to convict you, often the better. Now, considerations change depending on if the person is in custody while the case is pending. Certainly, they want to get out as soon as possible. But what I tell my clients is that rushing to the conclusion of the case does not necessarily mean getting out any sooner. So there's always a balance between doing things quickly and doing things well. And oftentimes the speed at which a case is resolved is sacrificed to make sure that the case is handled correctly. So don't just try to get it over with, because you might rush into a very bad situation. The other thing you want to avoid doing at your initial appearance or arraignment is trying to explain your side of the story. The judge just isn't deciding guilt or innocence at this stage, and you're going to take up time. You're going to, I don't want to upset the judge, but you're going to test the judge's patience, and ultimately no good comes of it. So if no good comes of it, it's not worth doing it. 3, will you be released or held in custody? Now, after you plead, the judge will decide whether you can be released or while your case is pending, and that is dependent on several factors. There are basically 3 possibilities for what the judge can decide. The judge can decide to release you on your own recognizance, meaning that no bail is going to be required. You just promise to come back to court when you're supposed to, and the court will accept your promise. The second possibility is that the judge sets a bond or bail where you have to put a certain amount of money up with the court before they will release you, and then that money is held by the court until the case is over. The idea being that it's a certain amount of money that is high enough in value that the defendant would really not want to lose that money by absconding, by running off and not showing up for their court hearing. So it's meant to create a strong disincentive for the defendant not to come back to court like they're supposed to. And so that's a possibility. And then lastly, as I mentioned earlier, there's the possibility that you're just going to be held in custody while the case is pending. And that's reserved for very serious cases or cases where the defendant has already demonstrated that they're just not going to follow the court's rules. Now, your attorney can argue for the least restrictive release conditions. Therefore, having a lawyer present is very helpful. In my jurisdiction, oftentimes it actually is counterproductive to have a retained lawyer show up at your initial appearance, because then the judge is going to get the message that you have means, you have money, and that's going to impact their thinking as to how high of a bond to set or whether or not they need to set a bond at all. Oftentimes, it is better to let the public defender handle your initial appearance, because the judge doesn't know what means you have. Everyone who has a public defender is sort of presumed to not have means. And so in my jurisdiction here in Pima County for initial appearances on felonies, the public defender already goes and represents all of the people showing up for their initial appearances on any given day, including people who would otherwise hire a lawyer. So I often tell my clients that, yes, you could hire me to show up for your initial appearance, but that actually might end up working against you. Now, in situations where there's just a lot of information that needs to be presented to the judge and there are somewhat involved arguments to be made, it might make sense to hire a lawyer to do that, because the public defender is just not going to have the time to get up to speed on all of those things to be able to make the best case they can. So it is dependent on what the circumstances of the case are. But generally speaking, if the court is already providing you a lawyer at your initial appearance, it's probably good enough. Step 4, what happens after the first appearance? Now, you see, your first appearance, it's just the beginning of the case. It's the necessary step to get things moving. After that hearing is when you'll likely have pre-trial conferences, motion hearings, and if necessary, a trial. After the initial appearance and before all those other things is also the time to work with your attorney and gather evidence, negotiate with the prosecution, and prepare your defense. In my jurisdiction, after the initial appearance, a preliminary hearing is set, but often the preliminary hearing doesn't happen. Instead, what does happen is that the state has that date of the preliminary hearing as its deadline to get what's called an indictment, probable cause determination by a grand jury. I'm speaking in the felony realm. So people often leave their initial appearance with a court date that's not actually going to happen. Then the state has to present its case to the grand jury, and if the grand jury returns a true bill or an indictment, formal charges, then the defendant receives an arraignment date where they will be shown their indictment with those formal charges. After their arraignment, that the state will start making disclosures, sharing the police reports, recordings, photographs, videos, forensic evidence with the defense for the defense to be able to assess the case and determine whether or not the state has the goods to make its proof beyond a reasonable doubt or not. So basically what happens after the initial appearance is the case, the working up of the case. So what is the key takeaway? Your first court appearance is important, but it's not where everything gets decided. Pleading not guilty so that your attorney can give you the guidance and prepare the case, takes things one step at a time, is huge. So the important thing is for you to remain calm. That initial appearance is not going to be the be-all end-all of your case. If you have an upcoming court appearance in Arizona and legal guidance, don't go it alone. Contact my office today so that we can discuss your case and prepare a strategy for you. Thanks for watching. Don't forget to subscribe, click the bell, whatever it is that we do here on YouTube these days. Don't miss my videos. I'm trying to put these out on a weekly basis to provide useful information and guidance to people who would otherwise be left to fend for themselves in the legal system. Most important thing to keep in mind is that although you may not want to hire a lawyer, probably the best thing for you to do because the system is complicated. I'm Joel Chorney, and I hope that you learned something today.